I'm going to go ahead and get us started here. Good afternoon and welcome to Mountain States Legal Foundation's webcast. We produce these webcasts to speak directly with our friends and supporters. We have loved the opportunity to dive deeply into a single case or issue to explore the ins and outs with all of you who make that work possible. If you received this webcast invitation from a friend and are unfamiliar with our organization, Mountain States Legal Foundation is a nonprofit, public interest legal foundation established in 1977. We are located just outside Denver, Colorado. Mountain States defends its clients pro bono in litigation in defense of individual liberties protected by our Constitution. At Mountain States, we believe freedom is worth fighting for. Some of those freedoms include the right to own and use property, free enterprise system, and most importantly for today's discussion, limited government. My name is Cristen Wohlgemuth. I serve as the president of Mountain States Legal Foundation, and I have the privilege of serving as your moderator today. Our panel are Mountain States attorneys, David McDonald and Cody Wisniewski. David has spent a lot of time since the pandemic came to America's shores, watching how our governments, and in particular our courts, are responding in relation to our civil liberties. Cody serves as lead counsel on the case we're fighting in New Mexico to protect your Second Amendment protected rights during this time. As you know, many states are in the process of easing quarantine restrictions. Some are doing so only after their citizenry began demanding it of them. Regardless, let's start today off by talking about the good, the bad, and the ugly of where we've been and what opportunities still lie ahead. For those of you who are joining us live, we do have the last 15 minutes of today's webinar reserved for the Q&A. If you look at the bottom of your screen, you will see a button to submit your questions that's labeled Q&A. You can also communicate with the staff via our chat window. So David, can you kick us off by framing our discussion for today, please?
Sure. Thanks, Kristen, and thank you for everyone for coming today. I hope you all are having a good afternoon, and I hope that what we say will be somewhat entertaining and somewhat informative. First of all, I'd just like to kind of make sure it's clear to everyone that there are multiple perspectives to look at COVID-19 and the various responses. And the different perspectives you have and how you look at these issues is going to change the way you think about them. So something even as simple as everyone has to deal with the kind of mask orders or the stay-at-home orders, your response to those orders is going to be very different if you're looking at it from an originalist, textualist, constitutional perspective versus a libertarian perspective versus a conservative or a liberal or socialist perspective. So I think it's important to keep that in mind.
Fantastic. Can you give us some examples of what some of those good and bad and ugly ideas are? We'll get into the specifics, the nitty gritty of some of those politics, some of those policies in just a minute. But what does the Constitution itself have to say about our situation?
Yeah. So around the office, we've kind of kicked around this idea of basically you can categorize most of the government responses to COVID-19 as kind of the good, the bad, and the ugly. So you have the good responses, these are the things that are largely uncontroversially constitutional that the government is doing. The prototypical example there would be people on a cruise ship where there's an outbreak on the cruise ship. Once they get back, the members of the passengers on that cruise ship put into quarantine in a local hotel or something for a limited period of time. That's the sort of prototypical example of exactly the sort of quarantine that the founders would have been very comfortable with. It's limited in duration, it's limited in scope, and it's highly targeted based off of actual evidence on the ground. And that's sort of the prototypical example of a good regulation that we can expect to survive constitutional muster. Then we have the bad. These are things that are clearly unconstitutional, both under originalist interpretation of the Constitution and probably under current law. These are the sort of cases, the challenges that you might actually have a chance of winning. And these are the examples of, for example, our New Mexico gun case that Cody can talk about a little bit later, or if you want to discuss that right now. And then at the end, then we have the ugly cases, which are the ones that we've been chugging Tums to try to deal with over here. And those are the ones where it's clearly something odious is happening here, but there's not necessarily an obvious legal remedy or constitutional remedy. And whether that's because the Constitution itself doesn't provide one, or whether it's because the courts have over the decades read that out, those are the ones where we can try to find something to fight, but there's not necessarily going to be something to fight, and we're just going to be really frustrated about it.
So, Cody, if we can go back to a bad, we do have a case that you're fighting on behalf of some folks in New Mexico that we've had another webinar on, but can you give us a 30-second overview and an update?
Yes, ma'am. So that case is Aragon versus the Governor Grisham in New Mexico, and that specifically challenged the governor's failure to indicate that gun shops, ranges, and repair facilities were essential businesses during the close down. And the key there is that these are businesses that are dealing in constitutionally protected property, and because of the scheme of both federal law as well as New Mexico state law, in order to purchase a firearm in the state, you essentially have to be in person to do the final transfer. So by closing those stores, the governor made it impossible for New Mexicans to exercise their Second Amendment protected rights. So we filed a lawsuit in April. Shortly after we filed our lawsuit and a motion to get that in front of the court as soon as possible, the governor decided to allow gun stores and ranges to reopen. So they are operating in New Mexico today under some of the standard COVID restrictions that are in place for other businesses.
Very good. So I want to get back to that response type in just a minute, but David, can I come back to you, please, and ask you to continue helping us frame this conversation by talking about what the Constitution, you gave us several categories at the beginning of your remarks. So can you talk to me about what does the Constitution itself say about the situation that we're in? What limitations does it have? What freedoms does it give? What rights does it protect? So on and so forth.
Right. So I think the most important thing to understand right off the bat is that while the Constitution is fairly clear about the restrictions it places on the federal government, as we all learned, or hopefully we all learned it in civics in the 8th grade, is that the federal government is a government of enumerated powers. It has only those powers which the Constitution expressly provides to it. Meanwhile, the states have what's known as the police power, and we can get into arguing about the scope of the police power for hours, but that's a little bit beyond the scope of this webinar. But the big difference is the federal Constitution restricts primarily the federal government and not the state governments. So, and since most of the reactions to COVID have come from the state or local level, it's to the state and local constitutions that we're really going to find most of the restrictions on what they're allowed or not allowed to do. Outside of course, you look at the Bill of Rights, so the First Amendment, Second Amendment, those types of violations, the federal government can step in, the federal courts can step in, the Constitution has something to say. But it's important to recognize that the Constitution has a lot to say about what the federal government can do. It's largely silent about the authority of the states. So they have a great deal of flexibility the federal government doesn't have. So that's the first most important thing to understand. The second is to understand is that you really do need to kind of get inside the shoes of people in 18th century America. It's important to recognize that the Constitution and the various state constitutions were practical legal documents created to solve practical real problems. So it's important to understand what they would have thought was within the acceptable levels of the police power at the time.
And David,
versus
I'm going to interrupt you just for a minute, because I think that needs a little bit more explanation. Why is it important for us to get into their minds to understand the constitutionality of or unconstitutionality of what we're seeing right now?
And of course, this is assuming that you ascribe to an originalist or textualist view of the Constitution, which we obviously think everyone should. Just for the simple reason that texts mean what they meant when they were written. That's how we read literally every other piece of text. If you had a contract and someone came and started trying to reinterpret the contract later on, you would think that someone was trying to pull something over on you. So it's important to understand what the Constitution means, the words that are on the page, what they mean, and what they meant at the time. And while that's very important, just generally, originalism in general. And here it's very important because we have to see, okay, what are the actual powers given to the federal government? What are the powers given to the state governments? What are the restrictions put on both? And what that would have made sense, the words on the page, what that would have made sense to people who are actually ratifying these documents in the 1780s and 90s. So
with that, Cody, as our resident Canadian American, can I get you to talk to me a little bit about what you've talked around the office a bit about what that perspective would be and what examples we saw of quarantine orders back in the day?
Yeah, so it's not as cut and dry as a lot of people think when you're talking about kind of constitutional restrictions. As David has mentioned, almost all of these would be unconstitutional if it was the federal government acting. I mean, but we have state governments. And when you're looking at the federal constitution, we have to look at exactly what the founders and framers would have been comfortable with. And the framers were comfortable with certain responses to pandemics, to mass infectious diseases and things like that. So, for example, General Washington, while he was general, quarantined the Army, the Continental Army, in order to protect it against, passing further disease, and actually inoculated the Army during that span. And later President Adams did something very similar and was very comfortable with quarantining. And this idea of quarantining, David had kind of mentioned that the clear okay example here was the cruise ships. And the reason for that is quarantining actually came from the idea of when a ship would arrive in the country, they would quarantine it in port if it had arrived from a place where there was an outbreak of an infectious disease, something like yellow fever. And quarantine actually derives from the French word for 40 days, and that's how long the ship would have to sit in port. So we won't dive all that into it, but there were definitely examples of the founders and framers being okay with this idea of very specific, very targeted responses to things like an infectious disease, something like COVID.
Okay. But David, I'm going to come back to you to get you to comment on how today's quarantine situation implies the limits and the powers of federalism.
Yeah. So if we're looking for silver linings here, is what we've seen from the response to COVID has largely been a success of federalism in action. Outside of the bailout, which is actually kind of crazy that we're just outside of the $3 trillion we spent. Which is ironic because the bailout would have been something that the framers would have been outraged by. Madison's head would explode at the thought of a federal bailout of that scale. Meanwhile, throwing someone on a prison ship to die in port because they have smallpox, that would be completely okay. So again, this is interesting, getting inside kind of the shoes, walking in the shoes of an 18th century person. Is their concerns is federalism for them was a very, very, very important paramount concern in a way that we don't really recognize it to be, most people at least today. And everyone sort of accepts that we pay lip service to it, but generally speaking, the federal government's the one in charge and the states are more or less administrative subdivisions of it. That's how most people think of the federal government. That's not how the founders thought of the federal government. That's not how Americans thought of the federal government at the time. So something like a bailout, something crossing national lines, the scope is something that would really, really scare them. Meanwhile, governors have a fairly free hand to act. And that's, I think, the benefits of American federalism. We've seen 50 different versions of how to respond to this. So we have the Governor DeSantis down in Florida response. You have the Governor Cuomo up in New York response. You have Jared Polis, who, as much as I hate to admit, has largely done a fairly decent job with some major caveats. But you have these different perspectives on it. So we get to see, okay, what works, what doesn't, outside of the models and the counterfactuals. We actually can see what restrictions work, which ones don't, which ones are violative of people's rights, which ones aren't.
So despite the fact that we are all, including those of us here in Colorado, chafing at the quarantines that have lasted for such a long time and the four walls of our homes are definitely closing in on us, the history lesson that I think that you guys have shared is that There's some precedent for what we're watching. But now that we've had our history lesson, I'm going to take us out of the academic and dive into actual policies. Let's start with the good. What are some of the more clearly constitutional responses that we've seen? David, could you answer that one for me?
Like we already mentioned, the prototypical example would be the ship coming into port with actual evidence of an outbreak. And again, and sort of around those lines, so stuff that would have been acceptable under traditional concepts of what the police power consisted of. And that's sort of the general health, safety, general welfare of the people. States are generally free to do that. So you have the state of ships coming into port, or if there's a particularly virulent outbreak in a particular city or town, kind of locking off of that town in a very specific quarantine that applies to both the infected and the non-infected alike. That would have been fairly common. The city of Philadelphia itself was put under martial law in 1792 during a yellow fever outbreak. I believe that's what you were referring to with Adams. So those types of things are probably going to be fairly uncontroversially accepted. So it's narrow in scope, both time-wise and geographically, and also based off of specific evidence of public safety danger. The further you go out from there, the more tenuous it becomes. But those are the basic ones that are most likely to be found acceptable. Certain, especially state level or local level, kind of social distancing requirements, something that where very few people are going to say that's a substantive violation of your personal liberty, but there's scientific evidence that it will help contain the disease. So stuff like that.
You could also draw an analog from something like the ship coming into port of traveling from a country that has like a noted outbreak. If you're traveling from somewhere that had a really high infection rate or had a really high death rate, let's say you were flying in from Italy when it was experiencing that really bad outbreak at a time, going into some form of forced quarantine that is put in place by the government would have been something that probably would have been totally fine with the framers. I mean, you're just drawing an analog there from a ship to a plane and modern means of transportation. But I think that would probably fall under a similar category.
Yeah.
So we have we do have a question and answer section of our presentation at the end of the presentation. So don't hesitate to use that Q&A button down at the bottom of your screen. But we have a particularly relevant question to the conversation we're having right now from Mark Patton asking, don't we quarantine the sick and not the healthy? Where does that fall into the equation that y'all are working out for us here?
I'll jump on it. Okay. We actually, the founders and framers were actually okay with doing a little bit of both. So it wasn't just necessarily somebody who was absolutely definitely sick, there weren't really presumptively positive tests unless you were exhibiting symptoms. So they were certainly okay with quarantining the sick, but they were also okay with quarantining people who were more likely than not to be infectious. So when you're talking about a ship coming into port in those contexts, they weren't just quarantining those that had symptoms of yellow fever. They quarantined the entirety of the ship because it was those that had yellow fever very obviously were infectious, but it was more likely than not that everybody on the ship, or most of them, were likely infectious. So there is some overlap with people who might not necessarily test positive or be exhibiting symptoms, as long as there's some sort of causal connection to this idea that they are likely or more likely than not infectious.
But at the same time, nothing at this scale would have been considered at the time. You do have situations, fairly extreme circumstances, where entire cities were put down into quarantine, but you don't have anything even approaching the level of the sort of statewide orders or people calling for federal orders, which luckily we haven't gotten yet. And I think, again, to nail down this issue is the stuff that really incensed the founding generation. And we're being a little sloppy. We don't mean just the founders and framers. We mean sort of what things were meant to, were expected to mean amongst the general populace. We can get into that later. but I just wanted to make that clear. But what they would have been concerned about were scope, scale, who is doing the acting, somewhat less concerned with the severity of the response and more the scope of the response. So something that crosses state lines, massive no-no. That's not okay to the founders. That's the sort of stuff that you get civil wars would start over, literally in some cases. There's a fair number of small little border skirmishes and stuff that took place in the early republic we don't tend to think about very often. But something like that would have really, really incensed them in a way that we don't really feel anymore. But a very restrictive instituting martial law in a city, if limited in effect and other restrictions are in place, that's something that they would have probably been more comfortable with than we are in the terms of just how severe the restrictions are on the individual. So that's, again, it's an interesting thing to think about.
Okay. So that gives us a good framework for the good. I want to move us into the bad, the clearly unconstitutional. Cody, you just gave us an update on what's going on with the New Mexico case. It seems that we got some traction because the liberty at issue was the Second Amendment. Is that the only reason it got traction? And what kind of cases do you see the courts actually being willing to take up?
It's not necessarily the only reason that we got traction. And it's not specifically that it was the Second Amendment, but rather that it's a right that the Supreme Court has deemed fundamental. And it's a right that's explicitly protected by the Bill of Rights and protected by the Constitution and, through the 14th Amendment. So the Second Amendment cases have been more successful, honestly, across the board in forcing governors to back down more so than actually necessarily getting court orders. So we filed, like I had said,
we'll take the W.
Yeah, we had filed our case, and we had filed for a motion to get it before the court. And before it went before the court, the governor allowed gun stores to reopen. Something similar happened in New Jersey, where the governor backed down. When the courts have addressed the Second Amendment cases, they've gone kind of both ways. Some courts have sided with the states, allowing them to close down. Probably won't surprise you that those are courts in places like California, and others have not. But a lot of the action in the Second Amendment context has been political pressure from the lawsuits. Now, there's other cases. So there's been a lot of First Amendment cases as well, dealing with free exercise and with people being able to gather for church services. And these have gone kind of both ways. So some courts have struck down orders that stopped people from gathering in religious contexts. This happened in Kentucky. But other courts have upheld restrictions on churches. And generally when those are upheld, they're upheld through either because there's some odd procedural process, which is what happened in Kansas, or because the church didn't really seek to comply with the general coronavirus COVID restrictions. So more often than not, even in these rights that we're talking about that are specifically protected by the Bill of Rights, the courts are willing to allow people and businesses to reopen and people to gather, as long as they're willing to do so under those COVID restrictions, under those social distancing guidelines, under those workforce reduction requirements. But places where they're just trying to operate as normal, it doesn't really seem like courts are willing to allow that to occur.
Got it.
Yeah. And I would say that basically what you're looking at here, a good way of kind of a shorthand of looking at if you can expect to see something actually get through the courts or not, is that the courts are generally going to be looking at, are the orders, the regulations, the statutes, whatever, are they treating people fairly? That's the primary. And again, I sound like something of a broken record, but what were these provisions in the Constitution written and ratified in order to solve? What problems are they trying to solve? And specifically, you're talking about the 14th Amendment, which is the route by which we get these constitutional cases against the states. That was created in order to start healing the country after slavery. This is to provide primarily for the civil rights, civil liberties of the former slaves. So the Constitution is very, very concerned with treating similarly situated people dissimilarly. So if you see situations where in the Second Amendment, and this comes up in the Second Amendment context or the First Amendment context, it's where it seems that gun stores are being unfairly singled out, whether explicitly or just because the people writing these orders never even consider the Second Amendment to be essential enough to worry about. It comes up that context. It comes up when these First Amendment, the religious exercise rules are, again, the generally applicable rules, people challenging those are not having a good time. But when you're challenging the unreasonable restrictions that are applying specifically to churches, that's where the drive-through services where no one was actually interacting with each other outside of, they were all within the bubbles of their cars, that being shut down, that there's no reason for that. They were complying with the otherwise generally applicable rules. We see that with if they were going to be about race, it seemed like this was being applied in a racially discriminatory way. Or if it seemed like local officials were using this as a chance to settle scores. Honestly, that's where we've seen most of the mischief so far, is these the essential businesses determinations. Is you see a lot of local officials taking this opportunity to settle personal scores or political scores in how they decide who's essential and who's not. So we see that with the hotel lobby has been hard at work, where we see in several different states restrictions on hotels were lifted, but restrictions on short-term rentals were not, which fits into an already existing kind of policy lobbying fight. Or we can see sometimes where it's individual businesses that people don't like, or people are going after bars, or people going after cannabis dispensaries or something along those lines. And those are the types of regulations that the courts are going to be willing to step in and stop. It's something that they're equipped to deal with. The how much is too much question is something courts are very, very, very concerned about overriding the democratic branches, as they should be. Perhaps we might sometimes think that they're a little too cautious in that realm, but they're going to be very, very, very cautious in judging the propriety of something or how well supported something is by the science. They don't want to do that. But they are willing to say, hey, this distinction you're drawing here doesn't make sense.
And I think we've seen that in several of the church cases that have gone up and that are going up. I believe just recently our friends at Alliance Defending Freedom took exception to a situation where public gatherings and restaurants were allowed to open, but the churches were still prohibited, and pastors threatened with jail time and exorbitant fees. Can you comment on that?
Yeah, I think that was actually just filed either this week or late last week in Oregon. And that's exactly the kind of the scenario that David's talking about, of the court's going to be concerned when you're treating similarly situated people differently. So if you're going to allow a restaurant to reopen and observe social distancing guidelines, then it's going to be very suspect when you don't allow a church to reopen while observing those same guidelines. And there's obviously that heightened level of scrutiny when you're talking about something that's explicitly protected by the Bill of Rights and explicitly applicable against the states, as opposed to something like a general operating business.
Right. So I think we may have veered slightly into the land of the ugly. So David, can you talk to me a little bit about what those ugly situations are that go completely beyond the pale in our conversation?
So I think the easiest example here are the really, really restrictive stay-at-home orders or the mask orders, especially when they're applied to large swaths of the country that are really just, they haven't seen the sort of the parade of horribles that we were led to expect. And all of those situations where it seems grossly disproportionate, most times in those cases, I think they fall into this kind of ugly category where all of us kind of see what the problem is. We think they've gone too far. This isn't okay. But there's not a constitutional remedy for everything, unfortunately. And that's the situation with I think me and Cody slightly disagree on some of the mask orders. But in the situation for, let's go with a general stay-at-home order for most people, that's something that the only real way to challenge it would be say that it's arbitrary and capricious. There's no relation to the facts on the ground. And again, like I just said, the courts are very reticent to judge, to second guess legislatures on those types of judgments. And there's just not a whole lot there. There's not a whole lot in the sense of legal remedies, just as trying to find lawsuits to bring. And also in the fact that under the original meaning of the Constitution, and this is something that I actually think it maybe have been somewhat short-sighted on the side of the framers, is that there just aren't that many restrictions on state power. They generally have a fairly free hand, unless they're violating something, say, for example, in the Bill of Rights. And it's unfortunate, but the solution to overzealous mask ordinances is going to be more likely than not in the legislative realm or in the public protest realm than is going to be in the courtroom.
Very good. So I'm going to bring in another question that is implied by the remark that you just offered, which is, again, from Mark asking, what about the Incorporation Doctrine? Doesn't that require that the states be held a little bit more to account for violating our civil liberties? Cody, why don't you jump in there?
Yeah, and there's a number of different ways that we've applied the Constitution against the states, obviously. Supremacy clause has always been an interesting suggestion. Due process clause, privileges or immunities clauses. So those are all different ways that we've sought to apply the Constitution against the states. But the key to remember, and what David's articulating, is that the Constitution is a document of enumerated powers. It gives specific power to the federal government to engage in a certain amount of business. But the framers were very much okay with the states having a lot of control over their own territorial bounds. I mean, the 10th Amendment is the prototypical and the clear example and kind of articulation of that. The idea was that you could, in a sense, vote with your feet, and you could change the way of your life by moving from one place to another, and that local governments were always going to be better armed to respond to the interests of their own citizenry because they were more closely related to them and because they had a clear kind of eye on what was happening. So yes, states are prohibited from acting in a way that violates your articulable civil rights and civil liberties. But this is that weird conversation we're getting into in what frame of reference are we using? Are we looking at this from a pure, unadulterated civil liberties question, this natural rights question? Are we looking at it through what the founders and framers would have been okay with some regulation on? Or are we looking at it through what the courts are going to say is okay? And this category, and what David's getting at here, is that this is a category where we're not exactly sure what the founders and framers would have been okay with in this context. We feel like it might violate our kind of pure civil liberties, but courts probably aren't going to find that as well. So yes, there are definitely constitutional restrictions on the states, but not nearly as many as are placed on the federal government.
David, if I can direct the questions back to you, and folks, as I mentioned questions, I just want to remind you that our question and answer session is starting momentarily, and you can get onto that queue by typing into the chat window or the Q&A button at the bottom of your screen. David, you had an example here in Colorado that you spent some time looking at that that perhaps violated an individual's right to access their property.
Yeah, and this is another kind of aspect of the kind of discrimination. Most of these situations where you actually can win in court is going to, you can describe it in some fashion as discrimination. And this is a situation where it was a county in Colorado banned non-residents from the county. We've seen this a few places. We saw Gunnison did this. I think we may have seen this. Some Florida communities have done this. They tend to be more resort oriented or older communities. They put restrictions on outsiders. Say no non-residents are allowed within the county, and that includes those who own second homes, vacation homes. And that's something that we're looking at potentially challenging until luckily the county rolled back some of its regulations to the point where we felt that it was no longer necessary, at least as things currently stand. But in that situation where you're discriminating against out-of-state people. And that's something that, again, we don't necessarily think about all that much now in a very sort of globalized national system that we work in, where most people don't know they're Congress people, but they do vote for president. But so the founders were very, very concerned with balkanization. Many people argue that the Constitution's primary purpose was as an anti-balkanization document. This was primarily in order to keep the nation together, keep it from splitting up into a bunch of competing little fiefdoms who were fighting with each other over tax rates and tariffs and all kinds of sorts of things like that. So restrictions on the right to travel from state to state are major problems under the Constitution. This is the right to travel, we find this in both the Privileges and Immunities Clause of Article 4, as well as Privilege or Immunities Clause of the 14th Amendment. This gets technical and everything, but generally speaking, your right as an American is to travel freely anywhere within the United States. The states aren't allowed to lock off their state from outside access. So that's something that I think is a good example of something that's not necessarily intuitively obvious that that's really unconstitutional, especially compared to other things that may seem on their face more restrictive, more violative of liberty. But this is something that, again, the Constitution was specifically drafted in order to combat. So therefore, there's a remedy available. That's what I was trying to get at with that, is that we have to look into what remedies the Constitution actually makes available versus what remedies we wish were available under our idea of what we think constitutions should be.
All right, I have questions coming in, so I'm going to turn to those. Mark is asking, we've referred to judicial deference to legislatures. However, these orders aren't legislative, they're executive. While the legislature may have delegated emergency powers to the executive, they can't delegate powers that trample state and federal constitutions. The question then turns to the bounds of emergency. What seems an emergency at the start, where the facts are few, as more facts become available, the emergency argument weakens. If the court sustains such an emergency, that makes such emergencies all too easy. Would you agree?
Yeah, in part. So the recitation there is, I would agree with. I think the key there's a lot of individual points of inquiry in that statement. You're talking about, does the specific order violate a articulable civil liberty or a natural right? What's the breadth of the individual state act that grants the governor the authority to act, and what restrictions are placed thereupon? You're talking about the interplay of 50 different state constitutions, all of which vary from state to state, depending. And then you're also looking at the exactly that kind of breadth of an emergency. How long is an emergency? Is an emergency 1 month? Is it 2 months? If some of these orders went on for, we can be flippant and say multiple years, then those are much more likely susceptible to a successful court challenge. But something that lasts 2 months, 3 months, and focuses on something where there's not a lot of scientific data that's readily available, that's when you get into a tougher question. So it's not very straightforward, and you've got to answer questions at each line of that inquiry. And that's where these become really difficult. And because it's an ever-evolving situation, you've also got the fact that these orders change every week, every 2 weeks. You go from being in a complete lockdown 1 minute to, I'm pretty sure I just got a notification that some of the restaurants I frequent are going to be opened back up to 50% capacity in Colorado here pretty soon. So there are a lot of problems that occur along this spectrum.
Yeah, and I think that questioner just really drilled down at it, because I think there are potential non-delegation issues here where it's, have the legislatures given sufficient guidance to the executive, whether that's the governor or the public health agency or what have you, in order to do their job so that they're not just ruling by fiat. And I think here, and this is tough. I think there definitely is a line at which point you cannot justify these restrictions, even the less restrictive ones. There is a line. The problem is that line is a mile wide and made out of cloud. It's very difficult to determine where exactly the line is. And at the end of the day, it's probably going to come up to the individual subjective judgment of each judge. How far do they think is too far? When are they willing to stick their neck out? That we may only get that answer retroactively. That may be the answer. Maybe no judge is willing to stick their neck out at all proactively because they don't want to be the one that people blame 100,000 deaths on. We may not get any real good relief until after this is over. Hopefully not, but that may be a real possibility.
Brad is going to pull you back to the beginning of Mark's question, which was essentially while the the judiciary has given deference to legislative actions, to be sure, Brad's asking what gives the executive branch of the various states the power to legislate, which is what they seem to a great degree to be doing.
So there's nothing that gives an executive branch power to legislate per se, but every state that I'm aware of that's passing these orders has some form of Emergency Powers Act statute. Mm-hmm. What that statute specifically says is, look, executive, you're better able to respond to immediate concerns. So we're going to give you the ability to respond to immediate concerns like a pandemic by issuing executive and public health orders that are necessary to preserve the public health of the state. And those are all constrained in some way. Most often, those are constrained by how long they're able to go. And there have been some successful state challenges based explicitly just on that length requirement.
Minnesota, I think.
Yeah, I think Michigan might have had one that was a 14-day requirement, and it went beyond that because it didn't set an end date. So, and this is akin to the federal government, right? I mean, when you look at responding to national emergencies, that's well within the president's power to respond to a national emergency. But if you look at something like declaration of war, that's something that should be considered by a legislative body. Mm-hmm. So in the states, it's akin to that. If the governor is responding to something that's an emergency and that needs immediate response, that's within the power. If they were going to be setting permanent policy for the state, that's something that the legislature is supposed to do. So it's that interplay of time there. And I think the idea that it's this question of when do you cross the line, right? It's not just one line. It's kind of multidimensional. It's what's the right involved? How long is it? So I think that there's a lot of interplay there, but the key there is that the power here comes from a specific legislative act that gives governors the ability to respond to emergencies.
Okay. And the danger here is that, as we all know, there's no way that the governments are going to give up their emergency powers once the emergency is over. We're still operating under the Patriot Act. We haven't declared war since Korea. So that's a good example to show how well those restrictions tend to work. And again, this goes into our good, bad, and ugly. Coronavirus is showing a lot of really ugly things about how we constrain our government. And hopefully this is going to be a silver lining going forward, is that citizens are going to realize, you know what, maybe those emergency powers statutes need to be rethought a little bit. Maybe our willingness to just blindly accept whatever the news is telling us is appropriate for our response, maybe we should be a little more skeptical of that. Not necessarily cynical, but maybe we should be more skeptical of that. Maybe we should be a little bit more aware of these emergency epidemic statutes when they're passed, because these aren't coming out of thin air now. These are all statutes that have been on the books, most of them since the SARS outbreak and stuff from 2003. A lot of the statutes are dating from then.
Some are from the 40s and 70s.
Yeah, but I had never read them before. Most of us hadn't, and that's a problem. We were not being vigilant about what the government was doing, and now in some cases we're paying the price.
So I'm going to, with our last question, and then I'm going to give us just a couple of minutes to wrap up. Gentlemen, I have a question from Carol and Chris McDonald, changing the question
Mom and Dad.
a little bit. My company instituted a policy today that says any employee coming to the office must use a health station to take their temperature and log it into some website. If your temperature is not within a specific range, you must go home. How do you feel about this and the risk to private medical information? Again, this is changing the question just a little bit because this is not government action, which is protected by or limited, I guess, by the constitutions. This is private action.
Yeah, I'm going to have to, this is not going to be necessarily the best answer you want, but there may be some sort of HIPAA type issue there with sort of a Health Information Privacy Protection Act, I think is the acronym. But that there, because there might be certain issues about privacy and what your employer is or is not allowed to do. I know in California there are issues about like drug testing, for example. There are very strict rules about when you can and cannot drug test. So there may be state law issues or employment labor law issues there, but that's a little bit beyond my purview.
And I think I mean, it's not necessarily the popular answer, but private companies are not restrained by the Constitution, and it's your decision to work for a private company. And if a private company wants to place specific restrictions on that contractual arrangement, that's up to them. And I think I'm actually going to zoom out a little bit here because there's been some interesting questions about this with national and multinational corporations instituting mask requirements versus cities and states instituting mask requirements. And those are two very different things. When you're talking about a city, a state actor, you're talking about something that acts on behalf of the people, is only empowered because of the people, and has restrictions on what it can do. This is where we're talking about those civil liberties violations. But when you're talking about private companies, it's well within their rights to condition your use of their property on certain performances and certain requirements. So something like, a national corporation saying, you know what, we're going to require people to wear masks in our stores. I'm not necessarily as offended by, I'm not concerned by, and certainly doesn't implicate constitutional concerns. Whereas that's very different when, and this is where David and I disagree on mask laws, very different when you have, a city or state saying, we're going to reopen businesses, but you have to wear a mask no matter what.
So, gentlemen, as we close our webinar today, where do we go from here?
Well, one of the things that is going to really play a part in moving forward is going to be where all of these lawsuits that have been filed and are pending go. We talked about them as of wins and losses, and I think I should probably clarify what we mean there. And when we're talking about wins and losses right now, we're talking about preliminary relief. Preliminary relief. Basically, that's the court jumping in early and saying, look, they're pretty clearly going to win, therefore we're going to let them reopen in this context. And that's what some of those free exercise cases have been, some of the free assembly cases have been. But that's not final relief, and that's not an authoritative decision of a court that we can rely on as binding precedent in the future. So how these cases move forward and how they play out will be really key to seeing what the next steps are going to be, because there's a lot of court precedent dating back to the 1920s and the 1960s where there were maybe not similar pandemics, but there were outbreaks. And there's some not great court precedent coming out of those times that we would argue violate civil liberties. And so I think that's going to be an interesting problem moving forward is do those cases move forward? How do they move forward? And what does the final relief look like?
Yeah. And I would say it's and this is something we like to say around the office, be intentional. When you're trying to seek change, what are you doing and how are you trying to do it? There are certain harms that are very well equipped, that the legal system is very well equipped to solve. There are certain harms that it isn't. There are certain harms that mass public action is very well equipped to solve, and some that aren't. So I think focusing legal efforts on those areas where we have a chance to make good law and to move the ball forward is something we can definitely do. That means focusing on those areas where you see the discriminatory conduct, focusing on the areas that we can actually move the ball forward.
And I just want to clarify one point. David and I have been talking a lot about, where these things are tough or where there's problems. And we're talking specifically in that category of how courts are going to treat these in a lot of those.
Right.
We're personally offended, and I'm sure a lot of other people are, over a lot of these regulations and how government has acted. And I think that's exactly it. I mean, your local officials are your local officials, so is your state. So, making sure your voice is heard in that context, and rest assured that in the contexts where there are viable legal challenges and where there are cases that we think we can set good precedent, we're actively pursuing those, and we're working with an ever-changing landscape. But
there's a lot of good people doing a lot of good work right now. We just got off a big conference call full of people working on this sort of stuff. So the fight's going on. As much as you may not necessarily see it every day, it's definitely going on.
And I think that is a great place to start wrapping this up, because there are some fantastic legal battles that we have the opportunity to win. Mountain States and our sister organizations across the Liberty Movement are taking those opportunities where they exist to fight for all of our collective rights. We had a lovely comment from one of our participants just now, who commented, and I'm going to borrow her words. I'm thankful for our forefathers and our foremothers who made sure the power rested with the people in the Constitution. They also believed in personal responsibility. Many of us see that these restrictions were based upon faulty information to begin with and are causing more harm than the virus itself. I'm 82 years old, and I can't believe that people have so easily given up their own ability to make choices. I agree with Ben Franklin that those who are willing to give up their freedom for a little safety will end up with neither. We so appreciate your remarks, because we at Mountain States, we fight for those natural rights that are enshrined in the Constitution, and we're grateful for the opportunity that you all give us to do exactly that. So thank you all for those of you who joined us live, and we look forward to doing this next time. For those of you who are not familiar with Mountain States, you can find out more information at our website. That address is www.mslegal.org, and we look forward to seeing you next time. Thank you.